Now, let's talk about the homeless crisis and some news from federal court this week that greatly affects homeless policy all across the West Coast. There is a reason that police cannot simply arrest someone for camping on public property at any time of day. It's because of a key court ruling. So let's explain how we got here. The case is called Martin v. the City of Boise, as in Boise, Idaho. You've heard of it. And it's been used to fight camping restrictions in several cities on the West Coast. In 2018, the Ninth Circuit Court of Appeals ruled a city cannot charge someone with a crime or give them a ticket for sleeping in a public space if there's a lack of shelter beds. In other words, nowhere else for that person to go. The judges declared that charging someone with a crime for sleeping outside when they have no other choice is really a violation of the Eighth Amendment, meaning it qualifies as cruel and unusual punishment. So, when there are headlines about camping bans, that Martin v. Boise ruling is often what legally stands in the way of enacting those. It's also a key component in Portland's daytime camping ban that hits the books tomorrow. In order to criminalize camping on public property with citations and the threat of jail time and fines, police need to prove that there are shelter beds available when the homeless person refuses to move their tent. They cannot just arrest them on the spot, and that's because of Martin v. Boise. And that brings us to the headline from this week. Yesterday, the Ninth Circuit Court of Appeals refused to rehear a case. The ruling stopped the city of Grants Pass, Oregon, from criminally punishing homeless people who sleep in public places when they have nowhere else to go. Last year, a three-judge panel from the Ninth Circuit said the city cannot enforce that camping ban. So the city appealed, asking for the full court to hear the case instead of just three judges. But according to yesterday's 155-page order, a majority of the court's 29 judges said no to a full court hearing. And now, according to the Oregonian, the lawyer representing Grants Pass says, no problem. The city's going to take the petition to the U.S. Supreme Court and ask them to review the case. It's worth noting that this case is taking a very similar path to that Boise case. Boise wanted the full court to review the ruling against it as well, but the Ninth Circuit rejected the idea. Then they brought it to the U.S. Supreme Court, which denied the petition to review its ruling, so it stands. So, will the Grants Pass case suffer a similar defeat in our nation's highest court? Well, time's going to tell, but there are a few passages from the recent 155-page order from the Ninth Circuit that are worth mentioning. The two judges who wrote the majority opinion said the Grants Pass camping ban indeed violates the Eighth Amendment, and their choice to not hear the case again is consistent with precedent. Okay, but a senior Ninth Circuit judge who was joined by 14 other judges did not mince words when he wrote a statement against this recent ruling. It is easy enough for us behind marble walls and sealed doors to dismiss the consequences of our decisions. But for those who call these communities home, who must live by the criminal violence, narcotics activity, and dangerous diseases that plague the homeless encampments buttressed by our decisions, the consequences of our judicial arrogation are harder to accept. The judge says the original Boise ruling invented a federal constitutional right to sleep on public property, and thinks the Eighth Amendment argument is wrongly applied when it comes to camping bans. Another Ninth Circuit judge who wrote his own dissent said the Boise and Grants Pass rulings, quote, use a misreading of Supreme Court precedent to require unelected federal judges to act more like homeless policy czars than as Article III judges applying a discernible rule of law. He went on to say the Boise ruling handcuffed local jurisdictions trying to respond to the homeless crisis, while the Grants Pass ruling, quote, now places them in a straitjacket. It's no secret the homeless crisis boiled over on the West Coast years ago, but it sure feels like tempers are starting to flare a bit in the federal courts. The two judges who wrote the recent majority opinion rebuffed those dissenting claims, saying they were mischaracterizing the rulings with exaggerations. They said their ruling does not allow homeless people to sleep wherever and whenever they want, saying that when there is space in shelters, places can ban sleeping anywhere in public. And if someone refuses shelter, that person can be punished. So, when you wonder about the legality and careful wording of Portland's camping ban, it's because of cases just like this one. Localities are forced to meander around the rulings and opinions to try and get a handle on the crisis on the streets. As far as the Grants Pass case is concerned, we're going to be watching closely to see if the U.S. Supreme Court decides to take up the case. It's a process that surely will not happen anytime soon.